President Boyd, Board members, and Dr. Delgado. SB 1327 requires school districts and private schools to report to the county superintendent's office severance, denial of admissions, expulsions, exclusions, exemptions, transfers, suspension information beyond 10 days of students served under IDEA or Section 504. The information comes to us from public and private schools. We take the information together and provide that to the state. You received, the office has received, and we gave that to Dr. Delgado and the board. Mrs. Rita Wolf has requested a hearing with the county board to discuss alleged denial of admissions by a private school where her children previously attended. Although she is a resident of San Bernardino County, her children were enrolled in the Los Angeles County schools at Our Lady of Assumption, the Archdiocese of Los Angeles. Dr. Thompson and staff did an investigation and provided facts and findings, and I'd like him to take that to give you further information.
Thank you. Dr. Thompson.
Thank you, Mr. Boyd, and members of the board, Delgado. As was stated by Ms. Benitez, one of the charges of staff is to do a preliminary study whenever we receive this information from the various schools, school districts, or private schools. And this is why we took a look at the information from Our Lady of Assumption, Archdiocese of Los Angeles. But two submissions were made by the school. In the first case, they did deny admission because they believed that the student was not able to participate in the academic program with minor adjustments or accommodations. As a private school, Our Lady of Assumption is not required to provide a modified curriculum for special education. So it was argued that this was a denial of admission to that particular school. In the second case, the Pomona Catholic Middle School, located in the city of Pomona, and the other school was located in Claremont, the student was also denied admission to the school based on the same reasons that the academic program could not be provided with minor adjustments. And again, as I stated in the first case, they're only required as a private school to provide minor adjustments to the curriculum. I should add that the student is served by a Section 504 education plan, and as a result of the denial of admission, both schools recommended to the family, Mrs. Liu, that the student enroll in public education. Mrs. Liu did submit to our office two requests. That she received copies of the SB 1327 report, which was submitted by the Archdiocese of Los Angeles, which we provided to her, and that her case be considered to be heard by the county board. I should note that in the statute, which is Education Code 48203, which describes, again, this process, it does refer to Education Code 489114, which says that each school district is authorized to establish a policy that permits school officials to conduct a meeting with the parent or guardian of a suspended pupil to discuss the causes, the duration, the school policy involved, and other matters pertinent to the suspension. It's a very unique statute because this is a statute that's used in the school district to discuss a situation where a parent may be appealing a suspension for disciplinary reasons. In our other view about this, it doesn't provide, although it's being used as a statute for a hearing, it doesn't provide any power of final decision to the board. Mrs. Luke did indicate that she felt that her child had been expelled from these particular schools. However, in our view, this was a denial of admission. If the student had been expelled for disciplinary reasons, there would have been a violation of Education Code 48900, some type of disciplinary action, but we did not find that. So it's the recommendation that there are other avenues to hear this type of case Again, the parent is alleging that there was discrimination based on the student's status. It's being served under Section 504. And so some of the remedies could be to refer the matter to a Section 504 hearing officer, the Office of Administrative Hearings, or the Office for Civil Rights to address the alleged discrimination. Open any other questions you might have.
The board members have questions of Dr. Thompson. Thank you, Dr. Thompson. Appreciate that very much. We have
Superintendent, I want to preface my comments by saying that I've already tried those avenues. OAH and OCR both declined jurisdiction on this matter, which is why I pursued other remedies. I appreciate your consideration here today of an issue that deserves your attention, namely the exclusion of children with disabilities in private school as a class. As I've shared with the board, my oldest child in 2005 was expelled from Our Lady of the Assumption School when she was in 3rd grade due to her disability. She had been at the school since kindergarten and was expelled simply because a teacher chose not to provide accommodations she needed, such as allowance to complete classwork at home and allowances to leave early or coming late in order to prevent exhaustion. At the time, the school's reason for my child's expulsion was that she would not be capable of participating in their program because of her disability. The Archdiocese entered into a settlement agreement with our family and after 1 year reinstated my child to their program. She graduated from Our Lady of the Assumption School and now attends an Archdiocese in high school. She just received an honor roll award and is doing very well at the school. The people who believed she would not be successful due to her disability were wrong. I felt a great injustice was done to my child and pursued remedies. I brought the matter up to the legislature. As a result, Senator Soto authored SB 1327 in an attempt to provide children with disabilities protections from being discriminated on the basis of their disability. It was unanimously approved by the California legislature and signed by the governor. When I was working on the legislation, I thought I was doing so for my future grandchildren. I did not think that my middle child would be yet another victim of discrimination. It is her story that brings me here today. My child had been enrolled in the OLA program since kindergarten and was in the 6th grade. She is a sweet, kind, well-behaved girl who works very hard. She had been identified as a child with a disability and had a Section 504 plan at OLA since 2005. She successfully met all the requirements of the 6th grade program and was on the honor roll, as well as received a Cool Catholic Award for good citizenship. I provided these documents to the LACOE staff. Any special education related services, including a one-on-one instructional aid she needed as a result of her disability, were paid for by our family. I never requested special education from the school, nor did I request a modified curriculum. After successfully completing 7 years at the school, OLA informed me that my child would not be allowed to attend 7th grade. The reason given was that my child needed, quote, special education to facilitate learning, end quote. The school informed me that they did not believe they could meet her special needs because they did not have a special education program. I believe that my child could access the curriculum with appropriate minor adjustment plans. Therefore, I informed the school we would not voluntarily withdraw her from their program. I informed the school the placement would cause her irreparable social and emotional distress and result in academic harm as well. She has a difficult time with transitions, and to have her move from the school she had been at since kindergarten was devastating to her. In a letter, Principal Boyle from OLA acknowledged that a change of placement for her would be emotionally traumatizing. Staff also acknowledged that the reason for her decline in performance on tests was due to more independent testing. This is documented in meeting notes by the OLA staff, and the testing was supposed to be done by Sarah's aide, one-on-one, in an environment free of distractions. The school violated the portion of the 504 plan, which stated specifically that my child would be tested one-on-one. This violation caused her educational harm and was later used by the school to justify their position that she was not qualified to meet the requirements of their program.
Thank you.
I welcome a mediation by a neutral party. I'm here to resolve the dispute, not to be adversarial with the Archdiocese. Thank you.
Our next speaker.
Counsel for the Archdiocese Archdiocese of Los Angeles. I do not agree to be filmed.
It's a public meeting.
This is probably not the forum to debate the particulars of this matter, although I do take issue with much of what Mrs. Luke has said here today as being inaccurate. However, there are numerous forms that Mrs. Luke can avail herself of for any claim of disability discrimination. She has filed a number of complaints at the USDA, which does have jurisdiction over the 504 issues at our schools due to the hot lunch program. I suspect she's here because she was not happy with the decision she received. She also currently has a matter pending for the same issues and under the same facts at the Department of Fair Employment and Housing, and that's currently pending. So I don't believe that there is any further action that this entity needs to take. Thank you.
Thank you.
Good afternoon, Superintendent and Board. My name is Dave Palmer, and I'm the Associate Pastor at Community Baptist Church, where we host a monthly meeting for parents with children with disabilities. I myself have a child with a disability as well. And I'm just here today to urge the Board's assistance in correcting wrongs that have been done to children with disabilities in private schools. Rita Lou's child is one example, but I can imagine that there are many more instances where parents are pressured into removing their child from a private school placement just because they have a disability. In this case, we are dealing with a church organization, a charitable organization. And as a charitable organization, one might ask why they would choose to take the most vulnerable in our society and exclude them from their programs as a class. This conduct certainly raises serious moral issues, but setting that aside, when the entity receives federal and state funding, there are additional legal obligations. I am familiar with the public stay put requirement. Basically, when there is a dispute about a charge at placement regarding a child, the last agreed upon placement can remain in place. The benefit of the child is the focus of stay put. I don't understand why a charitable organization would not allow the child to remain in placement while the dispute is being resolved. I also don't understand how the school could have been burdened in any way when all of the special education services that the child had received were provided at no cost to the school, but at the cost of the family. All the parent was asking was for the school to allow their child to attend with assistance of the instructional aid they provided. There is no burden to the school. It is my understanding that Rita Lou's child did not violate any of the policies of the school or committed any of the offenses for which expulsion could be warranted. The only reason given to the parent was the Archdiocese belief that the child was not able to meet the academic program criteria. What was the decision based on? On the stereotype that children with disabilities are somehow second-class citizens and only belong in the public school setting? Education Code 220 states, "No person shall be subjected to discrimination on the basis of disability, gender, nationality, race or ethnicity, religion, sexual orientation, or any other characteristic that is contained in the definition of hate crime set forth in section 422.55 of the Penal Code, in any program or activity conducted by an educational institution that receives or benefits from state financial assistance or enrolls pupils who receive state financial aid." Private schools are exempt from some provisions of the Ed Code. However, the Ed Code expressly refers to the educational institutions controlled by religious entities in section 221, which reads, "This article shall not apply to an educational institution that is controlled by a religious organization, if the application would not be consistent with the religious tenets of that organization." The request to include a child with a disability falls well within the tenets of a religious organization and is completely consistent with the religious tenets of that organization. I urge LACOE to allow this child to have her case heard. We must not allow discrimination to continue. Prior to disability rights laws, it was okay for a restaurant owner to exclude a person in a wheelchair because they did not want to build a ramp. There is clear public policy to afford people with disabilities the right to be included. Private schools should not be given the option to only serve non-disabled students. Thank you.
Thank you, Mr.